In today's episode, we're gonna cover the 7 most important points while buying or selling a home and signing a contract of sale. And for that, we've got the man, the myth, and the legend, Shahid Ali by himself. Thank you, brother, for showing up, and I really appreciate sharing with us all these 7 points. Thank you very much for everyone tuning back to our real estate channel. Today we got a special guest, dear friend of mine, Shahid Ali. We go back, 16 years now? 2004, I think we've met first time at Stars and Stripes Realty. Remember, I think you were an intern at Panoons.
Seems accurate.
Yeah, 2004, so 16 years. Shahid does most of our real estate transactions, closing. What do you do, about 50 transactions a month?
On an average, yes.
Give or take. So he knows what is he doing. That's why he's here to educate you on the 7 most important points while signing a contract. All right, here we go, guys. So first question, who prepares the contract of sale? It's not an immigration lawyer. It's not a criminal defense lawyer. It's a real estate lawyer like Shahid. So give us a little more about the preparation of the contract.
Well, first of all, Roger, thank you very much for inviting me, and it's a wonderful show, and I'm sure your viewers will take a full advantage of it. And when they come or when they go to sign a contract, they will have a complete understanding as to what they're getting into.
Yeah, that's the whole point. Really, for you guys as the buyers and sellers, when you heading into a real estate transaction, absolutely contract of sale, it's a very scary thing to sign.
Absolutely.
Right? It's the biggest contract of your life. So we want to make sure that before you do that, we really cover the most important 7 points. That's why I brought Shahid from Ali & Baines to explain us exactly, what it takes.
Exactly, and we're going to try to make sure that it doesn't become scary when you're actually getting into the transaction, because you know exactly what you're getting into. But before I talk about the contract, I must say this: purchasing a house in the United States is an American dream. It's the single most important transaction in anyone's life. Obviously, then you have to take it seriously. So the first thing that you do when you are getting into a real estate transaction is that you reduce your understanding, whatever the understanding that you have with the seller or with the purchaser, as the case may be. Reduce the understanding to a writing, and that means you enter into a contract of sale. The contract is the basic body which governs the rights and obligation of both the parties. Whatever you have agreed with each other, it has to be in writing. If there is any verbal
no handshakes.
Absolutely not.
No handshakes, guys, okay? So it's got to be in writing, it's got to be clear.
There is a law that is called statutes of fraud. With reference to a real property, when you're purchasing a house or any real property, the law says it has to be in writing. You cannot simply say, oh, you said that, or she said that. It has to be in the writing. If there was any understanding that was agreed upon outside of that 4 bodies of the contract, this is not enforceable. So you got to make sure that whatever the seller or the purchaser agreed, it has to be in the part of the contract. That's the most important document.
Got it.
When you are entering into the contract of sale, and if you have missed something, the only time you can add any additional terms in the contract is if both the parties agree.
So we'll be talking about after the contract is fully executed, the down payment check is cashed at the escrow account of the seller's attorney.
Once the
and
contract
then
is
something
signed,
comes up, so both parties have to agree. There's a different change.
Exactly.
Got it.
There cannot be any unilateral additions or deletions of the clauses in the contract once the contract is signed by both the parties. So it is extremely important that before you actually sign the contract, whatever the understandings are must be made part of the contract. So that is extremely important.
Got it. So who prepares the contract?
The industry standard is the person who is selling the property, he has to propose his terms. So the seller's attorney basically proposes the contract of sale. That is the initial draft that is proposed to the purchaser's attorney. And then once the purchaser's attorney receives the contract, he has to sit with his client and then goes over all the basic terms of the contract of sale.
So there's basically 2 different attorneys. One that represents the seller, and he's the one who prepares the contract. And there is a second attorney who represents the buyer, and he receives the contract, reviews the contracts, go over it, and signs it with the buyer, correct?
That is correct.
So two different attorneys, okay?
That is correct. And Unlike certain states like Florida, where you don't need an attorney, in New York State, you need an attorney. That is required by the New York State Bar Association, and there's a reason why. In Florida or in certain other states, property prices could be as less as $50,000, not in New York State. Particularly in the New York City, you're talking about at least $500,000 of an investment. It's probably the single most largest investment in anyone's life. How can you not have an attorney looking and protecting your interests? So if you do not have an attorney, obviously you're exposing yourself to a potential risk of losing a lot of things, and that is not possible, and that should not happen.
Perfect. Second question, which is very important from the buyer's point of view. Is there a situation buyer can actually lose the down payment? Because I know usually you guys as an attorney like to see the 5 to 10% of the purchase price, right? So let's say you're purchasing a property for $800,000, 10%, that's $80,000. People are always scared to write a check for $80,000 to an attorney's name, right? Is there a situation that the buyer can actually lose the down payment?
Now, understand when it comes to the deposits, it's an earnest money deposit that is kept by the seller's attorney who is acting as an escrow agent. The first question typically is asked by the purchasers, what is the sufficient amount of the deposit? There is no law governing the amount. It's called freedom of contract. Whatever is agreed between the buyer and the sellers. Now, the industry standard is if the purchase price is about $500,000, $10,000 is considered as a sufficient good faith deposit. If the price is over $1 million, generally acceptable deposits are 5% or 10% of the purchase price. And as the price goes up, the deposit goes up.
So who determines what the down payment check is? Is it an understanding between the buyer's attorney and seller's attorney? Is always negotiable? Because I know the buyer obviously wants to put as low down payment as possible, maybe the $10,000, but I know the sellers, they're always looking for a bigger down payment just to really make sure that the buyer is serious and putting some money up front. So who determines whether it's a $10,000, $50,000 or $100,000?
Good question. Both the buyers and the sellers. Now understand, the reason why you're putting some money down is to demonstrate your good faith as to how serious you are about this transaction. Why? Because the seller is not going to be able to do anything with this property for at least another maybe 2 or 3 months until this contract is terminated or actually closes. So the seller thinks like this: if I have signed the contract and 2 or 3 months down the road, the purchaser has potentially violated the terms of the contract, what do I get out of this? So if the stakes are higher for the purchaser, it's unlikely or highly risky for the purchaser to terminate the contract.
Understood. So basically the buyer, by putting the down payment in the name of the seller's attorney, who will keep it in the non-interest escrow account, basically gaining an exclusive right to purchase the property. So nobody else can come in and bid more money and purchase the property. Is that correct?
That is absolutely correct.
Gotcha.
Now, obviously when you're leaving $10,000 or 5% or 10% of the purchase price, potentially sometimes hundreds and thousands of dollars,
difference.
The money is transferred from your account into the seller's attorney's account, who acts as a neutral escrow agent. The purchasers are thinking...
So basically the seller is not getting a penny till the closing?
Absolutely not.
So the money is cashed from the purchaser's account, but it's held in an escrow account.
It's held in an
Got it.
escrow account, which is maintained by the seller's attorney.
Got it.
Now, escrow accounts are unique accounts. They are known as IOLA accounts. They're only maintained by the licensed attorney in New York State. And within the contract of sale, there is a detailed escrow agreement, which basically governs as to what will be the terms and conditions for the release of that deposit. The most important thing for a purchaser to understand and know that there are very, very narrow and limited situations where the escrow deposits can be released. There are only two situations in which the escrow deposits can be released. Number one, the escrow agent gets a written authorization from the purchaser. But purchaser is saying release the money, so there is no issue now. If the purchaser is not giving the release, there is only one other exception in which the escrow agent can release the deposit, and that is a written authorization from the Supreme Court judge.
Understood.
Now, how does that happen? The seller's attorney, who's the escrow agent, is going to approach the judge. He's going to ask the judge to allow him to release the money. The judge is not going to do that. The judge is going to say, I need to hear from the purchaser then. The judge will then
So
require
we're talking litigation now.
a litigation then.
We're talking litigation.
Exactly.
So there's a dispute.
Dispute, which is very rare in a real estate transaction.
Yeah.
Almost 99%
I've never
of the
seen
time.
it in 15 years, by the way. I've never seen a dispute.
Of course, because
Because you're an attorney.
the amount of transactions that we do, I have seen at least in about 5 or 6 transactions where the escrows have been
in what,
litigated.
15, 16 years?
In about 10,000 transactions.
So 5 out of
10,000 transactions that I have closed.
Fabian, you got a calculator? Can you do the math real quick?
So it's the important thing for the purchaser is that their escrow deposits are safe, so long as the purchaser is not willfully violating the terms of the contract. Their escrow deposits are safe. At the time of the closing, when the purchaser is completely satisfied, he receives the key and a possession, everything is fine, then he is going to authorize the release of his deposit.
So is there any situation the buyer actually can lose the down payment?
Yes, he can, but they're very limited situations, and I've rarely seen that happening also. Now, what will be a situation where a potential a loss of a deposit happens? One example that I have experienced is the purchaser signed a contract, everything was fine. A month or 2 months down the road, the purchaser found a better property which was lower in price and better in quality. So the purchaser thought, wait, why am I spending so much money on this crappy house where I'm getting a better deal next door?
Wow.
So he changes his mind. Now understand, changing of mind is not agreed in the contract of sale. So if the purchaser is saying,
So after the meeting of the minds, there's no change of a mind?
there is no, once the contract is signed, you cannot unilaterally terminate the contract of sale. If you attempt to do that, then you are violating the terms of the contract, which then gives rise to the seller to hold you in default, and then that can potentially give rise to a loss of a deposit. Now, understand that. When we say a unilateral termination of a contract, it's not possible only for the buyer, it's not possible for the seller as well. So if the seller a month down the road suddenly finds a purchaser who's paying $100,000 more than the purchaser is giving.
Got it.
Okay?
So it's both ways.
Exactly. So the seller will say, buyer will say, listen, it's unfair with me. You already signed the contract with me. How are you terminating the contract? Even in that case, just like the buyer could not terminate the contract, the seller cannot even terminate the contract. So it's a double-edged sword. So both the parties have equal rights and obligations under the contract of sale.
Got it. Perfect. I mean, that pretty much covers the second question, the second very important point. Third, are there any clauses that are time sensitive?
Yes, there are certain transactions, certain obligations that are meant to be time sensitive. The number one clause would be the time for the purchaser to obtain a financial commitment, a mortgage commitment.
Got it.
Typically it's 30 or sometimes 45 days from the day when these purchasers and the sellers have actually executed the contract.
So once the buyer and the seller signs the contract, the time start ticking.
At that point, yes.
So you got between 30 to 45 days to obtain a commitment from the bank.
To obtain a commitment.
What if you miss the date? Because it's very common, you know, banks are slow, the purchasers don't turn their documents in time, right? There's delays. What happens if they don't meet the 30 or 45 days day period?
All right, so that's very important. So if you have not received your mortgage commitment within the time that is allowed in the contract of sale, it is important that you preserve your rights under the contract. What I do typically is that I add a clause in the rider to the contract which says the purchaser has a right to get an extension in time, a reasonable extension in time.
What would be a reasonable extension?
Typically it's 15 days or sometimes 30 days.
Got it. So you got the 45 days and then you get another 15.
15
so you can go up
days.
to 60 days.
Exactly. Now, if the sellers do not agree somehow, or if you are unable to convince the seller as to what your position is, then you're really at the mercy of the seller. If you do not have a commitment within the time allowed in the contract of sale, the seller then has the right to cancel the contract and return your deposit. You do not have any rights or recourses at that point. However, the industry standard is when you have when you have demonstrated your good faith, and what is good faith? Right after signing up the contract, you submitted the application for the loan with the bank.
Got it.
You paid the
So
fees.
it's not like you sign the contract and now you start shopping around for the mortgage. You go to 10 different banks, you take your sweet
Which is
time.
fine, which is fine. But
you gotta make sure
you gotta
got
act
45
fast.
days.
You gotta act fast.
Correct.
But the good faith is not that signing the contract and then you left for a vacation, extended vacation for a month. That is no good faith. So you
went and you leased a new car
exactly
and bought a furniture.
undertook huge financial obligations. So you gotta focus. It's a huge obligation that you're undertaking. So to demonstrate your good faith, right after signing the contract, you start the loan process, you submit the application to the bank, you pay whatever the customary fees are to the bank. For example, the appraisal fee is very customary. You pay them your fee. You submit all the customary documents like tax returns, your W-2s, your bank statements, any other standard documentation that the banks typically require. You submit them to the bank. And then at that point, the bank is reviewing those documents.
Correct.
Sometimes they take time. Sometimes there are additional documentations required. Sometimes, for example,
especially this time of the year, the issues we have
with the tax returns.
with the
The
tax returns.
The
Correct.
banks require the tax transcript directly from IRS, and the IRS is backlogged, so
Correct.
it can delay. So in those situations where the purchaser has done what he was supposed to do, now it's not in his hand.
Understood.
In that situation, if 45 days have lapsed and the purchaser has still not received a mortgage commitment, sellers usually have an incentive to actually give him an extra time. Because in reality, if they do not, then they have to make a decision. They can cancel the contract,
have to return the down payment back.
down payment deposit,
And start all
and then
over
start
again.
all over again, which
All
doesn't
over
make
again.
any sense.
Right.
So it rarely happens, but it can happen, which is why I encourage my clients that they should try their best to convince the sellers to at least give them a right in the contract to have an extension, at least a one-time extension to obtain a mortgage
So
commitment.
basically try to get from the beginning the 45 days
Exactly.
instead of 30 days. And then you got 2 weeks extension. You got at least 2 months in order to just get the commitment.
That is correct.
Now, after you get the commitment, what's the other sensitive date?
So time for the closing. Typically,
closing,
it's about 60 days. Now you would see there are two terms that are typically used in the contract of sale when it comes to any time-sensitive clauses. Wherever it says on or about,
On or about?
that refers to this is a legal concept which says an approximate time frame, which is not a definitive time frame. When it says on or before, that is time sensitive. That makes time of the essence. Wherever there is a on or before clause used, you got to watch out and you make sure that if you're not 100% sure that you will be able to perform your part of the bargain under the contract of sale prior to that date, then you better make sure that you do not agree to that and actually try and convince the seller to agree on or about date. I typically convince my clients that they should not actually compromise on those kinds of dates. If for example,
we never know what the issue
exactly,
will be there,
if for
right?
example they are getting a mortgage and it's not in their hand, they should not agree on a time-sensitive dates, particularly for the closing dates, because then that potentially exposes them to a risk where the seller can actually take them to a task and just force them unreasonably, and it's not reasonable. And the sellers, for most part, understand that too, but once in a while you do get into transactions where sellers really put their foot down and say no, take it or leave it. I usually encourage my clients that then they have a decision to make. If they're not 100% sure, then I think it's wise that they do not agree with this and move on to another transaction. So yes, there are certain time-sensitive clauses in the contract which you got to watch out very carefully and try and negotiate those terms.
So basically, we got first, which is the commitment date, 30 to 45 days, possible 2-week extension, 50 days extension. Can we get more than one extension?
Yes, it's possible.
Possible.
Again, it really depends as to how far have you gone.
Understood.
At that point, you will have to basically convince the seller by providing him some documentation
Understood.
as to what have you
Making
done.
Basically making them feel comfortable that
Comfortable that you're not wasting his time and that everything is done in good faith.
And then the second important date, you said closing on or about. That's the second important
That is the
date.
second most important
Got it.
date in the contract of sale.
So, and you said about means you can go past what, like another 30 days?
The,
Is
in,
about?
the courts have interpreted that time frame of on or about to be about 30 days less or 30 days more than the date that is written in the contract of sale. Now,
So in other words, let's say it's March 30th on or about, so we can pretty much go to April 30th. That's the understanding.
that is correct.
Got it. So that gives you the cushion of 30 days to clear the title, and if there's any issues.
Whatever the issues are
Got
involved, that is causing the delay, yes.
So far we covered 3 important points. Number 1, who prepares the contract of sale. Number 2, is there a situation that the buyer can actually lose the down payment? And number 3, what are the time sensitive dates in the contract? So let's get to number 4. You ready?
Absolutely.
Alrighty, so number 4, guys, is there a situation that either the buyer or seller can actually cancel the deal?
The simple answer is no.
Okay.
Just like both the parties enter into a contract mutually through a mutual consent by agreeing to all the terms of the contract, you cannot unilaterally terminate the contract either. So when you're getting into a contract, there has to be a consent by both the parties.
Got it.
And when
So
you're
it has to be
terminating the
consent.
contract, you also have to be consenting to the termination
Because
also.
I've seen cases when in the process of obtaining the mortgage, there were layoffs, and now the purchaser had lost actually a job. And by losing a job, they were not qualified for the mortgage, right? So that could be one of the situations when basically, unfortunately, the buyer is no longer able to obtain a financing, therefore he'll be able to get out of the deal.
We'll talk about this mortgage issue a little bit later.
In the mortgage clauses, okay.
Yes, but here's what I will say. There are certain limited situations where one of the party can unilaterally cancel the contract. The only time a party can cancel the contract unilaterally is if and when the other party is unable to honor their part of the bargain. When, for example, the seller agreed to remove tenants from the property, or they had agreed that they will remove the violations from the property.
And this happens a
And
lot
they're
in the
saying,
marketplace.
and now they're saying they're unable to do or unwilling to do that. This gives right to a purchaser that they can potentially cancel the contract.
So they basically breach the contract, and that gives them the out.
Exactly. Similarly, the purchaser has agreed to close the transaction within a certain time frame. If the purchaser has taken an unreasonable amount of time, then obviously the seller would obviously feel the heat, and he will say, listen, I gave you 45 days. I gave you an additional 30 days. I give you another 30 days. And now it's at a point where I have my plans. So I cannot just be sitting for you forever where there's no closing in sight for you. So at that point, the seller can lose his patience and say, I gave you more than enough time, so I'm canceling the contract.
And
So
this,
that-
if is it then past the on or about, if it's past another 30 days, then that's when the seller has actually a right to cancel the deal?
Well, they cannot outrightly cancel the deal. What typically happens is, at that point, the seller's attorney is going to issue a notice, what we call as a time of the essence notice, which basically allows the purchaser's final 30 days to close. If they're still not able to close, at that point, the seller has a decision to make. Either they can simply outrightly terminate the contract and refund the deposit to the purchaser, or they can hold the purchaser in default. Obviously, default doesn't mean necessarily that the purchaser is going to lose the deposit right away, but yes, that can complicate the situation. Bottom line is, neither party can unilaterally terminate the contract. I gave you an example earlier.
Yeah.
If the purchaser, say, finds another property which he thinks is a better property than the one that he's instantly purchasing, he may try to do that, but if he's trying to do that, then there will be some consequences. He can lose his deposit. Not only deposit, the seller can actually sue him for additional damages. Similarly, if the seller is saying, okay, I signed the contract, what's the big deal? I'm not selling you this house anymore because I have another buyer who's paying you more money. So why should I sell you for a lower price? Well, because you signed a contract of sale. Okay? That is enforceable in the courts of law. There is a thing called specific performance of the contract. If the seller says, I'm not selling you this house anymore for no reason, meaning he has changed his mind, and the changing of the mind is not agreed in the contract, which means he's breaching the terms of the contract. In that case, the purchaser is going to take the seller to the court, and the judge is going to force the seller to actually sell the house to the same purchaser. So there are rights and obligations which are exactly the same for both the parties. So no, there are very limited situations, but they are very unique to circumstances and situations which are very rare. Bottom line is, neither party can unilaterally cancel the contract.
Clear. Now, number 5, very important, mortgage clause.
That's the most important clause in any contract of sale. 99% of the purchasers who are engaged in the process of purchasing a real property, they obtain financing from their banks. Obviously, as I said, average prices in the city of New York is $500,000. Nobody carries that kind of cash in this age. Typically, people put about 10%, sometimes 20% deposit, and then 80% is financed by their lenders. In the contract of sale, it is extremely important that you negotiate if it's not there, and make sure that the contract of sale provides you with a mortgage contingency. Mortgage contingency refers to your rights that if your mortgage is not approved, you have the right to cancel the contract and get your deposit back. If this clause is not in the contract, that means you are saying to the seller, regardless of whether my financing is approved or not, I am going to still buy the house. How? Well, of course, if you have cash, then you can buy. And if you do not have cash, then you're potentially exposing and risking your down payment deposit. So that is extremely important. Now, in the mortgage contingency clause.
So let me just stop you. So if you represent the buyer, it's your job as an attorney to make sure this mortgage clause is in place, right? Why would the seller's attorney not allow you to put the clause?
So there are certain unique situations. For example, if the property is hot, there are multiple buyers, okay? And then in order to make the deal a little sweet for the seller, basically the purchaser is giving an incentive to the seller, showing his confidence.
That's a high risk.
It is indeed a high risk, but then you have to be absolutely sure. How can you be sure? Now you have already, let's say, gone through the preliminary underwriting of the mortgage commitment.
Understood.
There are good ways of doing it is, you can approach your bank, you can submit all your financial documents, your credit history, all that. And if your loan officer has given you an initial conditional commitment based on your financials, then basically all the bank is looking for is the property details. In that situation, even though in my opinion that is risky, but yes, the risk is mitigated here. If the purchaser feels
you did the work beforehand.
Exactly. So in that situation, the purchaser can consider taking a certain amount of risk, but of course, it's a responsible risk. If you have not gone through that process, if the bank has not run your credit, who knows there is an issue, right? So if there is a credit issue, if there's a collection against your name, if there's a judgment, if you sometimes filed a bankruptcy 10 years ago and you thought it's not an issue, well, it is an issue sometimes for a bank. So there could be a lot of reasons which can complicate your mortgage situation. If you have not gone through that underwriting process with your bank, do not agree to a cash closing. You must preserve your rights under the contract in this particular clause of mortgage contingency, so that if your mortgage is not approved, you should have the ability to cancel the contract.
So basically you get a denial letter from the bank that for whatever reason the mortgage was denied, and then you should be able to get your deposit back.
That is correct. Your obligation under the mortgage contingency clause is that you must apply for a mortgage immediately after signing the contract, and apply for the mortgage in good faith.
What's immediately? Is there a time frame or?
Sometimes in the contract of sale it says 7 business days. Sometimes it says 10 business days.
Got it.
Typically it's about 7 to 10 business days.
So it's much better. It's much better for the purchasers do a research beforehand and talking to a couple of different banks and making sure what they pre-approve for and if everything is clear.
Absolutely.
Then signing the contract and then starting the process and trying to collect the documents and see if they get qualified.
That is correct.
Got it.
I strongly encourage all the potential purchasers that they must actually consult with their loan officers or the banks, whoever they are consulting, before they actually enter into a contract of sale, so that at least they know what their financial situation is. Now, I'm just going to re-emphasize on the importance of good faith. When you have signed the contract, you have to demonstrate your good faith. As we talked about earlier, the good faith is a subjective term, but we can have certain objective standards here. After signing the contract, if you have taken an unreasonable amount of time, it complicates your situations. So it's important that as soon as you have signed the contract, you immediately start the process of financing.
So no vacations, basically.
No vacations, no shopping around too much. Sometimes purchasers are nervous, sometimes they're misled, so they start going around shopping for the mortgage rates.
5 different banks.
5-10 different banks. They take time and they get confused, and that obviously complicates the situation. So immediately submit the application to a lender, provide all the customary documentation that is required, stay on top of it for at least about 30 days. Even after doing all that, if the bank declines your application, they will then issue a document called denial notice. They have rejected it. One more important clause in the mortgage contingency, that clause requires, as soon as the bank has issued a denial notice, you must immediately inform the sellers about that decision, because they're entitled to it, because they need to move on with their life.
Absolutely.
They want to find another buyer. So if you sit on that denial, grieving and crying as to why did that happen,
Or maybe go to another bank and try to apply for another mortgage. Maybe, okay, you guys can't do it, I'm going to go to another bank.
which is perfectly fine, except because the contract requires the purchasers to inform the sellers immediately, they must do that so that at least their rights under the mortgage contingency clause is preserved. You must immediately inform the seller's attorney, and then at the same time request for an extension, telling them that you are still confident that if you go through another lender, it's
Maybe
possible that
maybe
your
a
mortgage
different
can be
program,
approved.
Maybe a different program,
Exactly.
maybe a co-signer.
Exactly.
But again, the denial letter has to go out to the sales attorney, inform them, and then see if you can get a little more time to go look for another option.
That is correct.
Got
In
it.
this, while we're talking about the mortgage contingency, one of the issues that frequently purchasers ask, what if the property does not appraise for as much
That's
as
very common.
what we are paying for? What happens then? So because it's a different question, but it's related with the mortgage
Very.
clause. The banks do not give loans based on the purchase price that the buyers and the sellers have agreed in the contract of sale. They give you the loan based on the actual value of the house.
So
If, for example-
they don't look at the contract price, they look at the appraised value.
They do look
So-
at the contract price
so
too.
So which one is lower of the two, or higher, or
They look at the value of the property.
it is determined by the appraisal?
That is determined by the bank's appraiser.
Got it.
So what happens if the property is underappreciated? The contract price, for example, is agreed as $500,000 in the contract of sale. The bank's appraiser goes down to the property, gets together all the facts and figures, and determines the value is $450,000. So what happens to those $50,000 now? Typically, the bank will not honor the mortgage that the purchaser has applied for in the amount that he's applied for. Why? Because he's only putting, let's say 10 or 15 or 20%. He's putting 10 or 20% based on the contract price. But the bank is not going to give you the loan based on the contract price now. So they will lower down your loan amount,
Understood.
which would require the purchaser to come out with additional down
More
payment.
money.
If he doesn't have that kind of money, that obviously raises a lot of questions. So I usually encourage my clients that they also add an additional clause in the contract, which I usually add in a rider, which says in the event the property does not appraise for the sale price, then unless the seller agrees to reduce the sale price to the appraised value, purchaser has the right to cancel the contract. Or in alternate, the purchaser and the seller have the right to renegotiate the price. Sometimes it happens, seller is, they can meet in the middle, or the purchaser can say, no problem, I can pay the full difference out of my pocket. He still nevertheless
Very
likes the
common.
property.
We see it all the time.
Exactly.
I really like the property, I don't mind
Exactly.
putting extra $10,000 as a down payment.
Exactly.
And I want
But
to close.
the important thing is, if the property is not appraised for the sale price, it is not an obligation on part of the purchaser to pay the difference out of his pocket. Instead, the purchaser can ask the seller to reduce the price. If the seller says no, then the purchaser has the right to cancel the contract and ask for the deposit back. So that is a relevant clause when we talk about the mortgages.
Mortgage cost makes sense.
Yes.
All right, guys. So number 6, what about physical condition of the property? So that's very important.
That's very important, and we get a lot of questions regarding that. And it happens in most of the situation where the first-time home buyers are looking at the property. There are a lot of physical issues in the property, particularly when they do an inspection. The inspector is going to reveal a lot of problems in the house.
That's his job.
That's his job.
Right.
So I
Better
always
find something.
I always tell my clients, don't get nervous and look at it this way. You're not buying a brand new car, you're buying a used car. And when you're buying a used car, you cannot expect the car to run like a baby. There will be some problems. But as long as the problems are not of the serious fundamental nature, for example, the engine is about to break down, you should be okay with that. Because, the house...
Little tune-up, basically.
Exactly, just tune up, changing the oils, changing the tires and stuff like that. House is exactly the same condition.
So typical wear and tear.
Exactly. Unless the house is a newly constructed property, which comes with certain warranties from the contractor that last for 1 year, within which time, if something happens, the contractor is responsible to fix that. All the houses in the New York State are sold as is, which means whatever the condition of the house was at the time when you saw the house for the first time, the seller undertakes to give you the possession of the house in exactly the same condition on the day of closing, with all the goods and all the bads. Now, if you don't like the bads, the time to negotiate is prior to signing the contract. Now,
so the inspection is done
prior to signing.
So the offer is accepted, and then the following step will be the inspection.
Exactly.
And then if the issues are not major, if there's the boiler is not working, the roof is gone, and something that you're willing to deal with, then it will be a meeting with you when you basically discuss the repairs and see if we can negotiate something with the seller or maybe get a possible credit. Is that correct?
That is correct. You can negotiate with the sellers about any potential improvements or any repairs. The sellers are not typically inclined to improve the property because it's not a brand new property. They are sometimes, not all the time, open to consider to at least make certain repairs. Now, let me just tell you, you have to understand what is the most important thing in the house. There are 4 most important things in a house: the roof of the house, heating system, plumbing system, and electrical system.
Most expensive.
Most expensive and the most important. If you take out these 4 things from a house, what is left in the house? Sheetrock and the floors and the windows. There's nothing else in the house. So as long as these 4 things are fine, you should be okay. Don't look too much into small things. In the contract of sale, almost 99% of the times, there is a clause in which the seller makes a representation. The seller promises the latest by the time of closing, when the seller actually gives you the keys for the house. He promises the roof will not be leaking and the heating, plumbing, and electrical system will be properly functioning.
Working condition.
Working condition. So that means that should give you a peace of mind. A day before the closing, you should go back to the property, which under the contract of sale, you have the right to go back to the property and to make sure the house is in the same condition.
You said that 1 day.
1 day prior.
Not at the time of the closing, or not a week before, preferably about a day.
Typically a day before, so that if you notice something different, for example, the roof is leaking, or the heating is not working, there's something wrong with the plumbing, you can give a reasonable opportunity to the seller to make certain repairs.
Understood.
Okay, if you do it the same day, it's almost impossible for the seller to do that. So go back to the property.
What would happen in that case? Let's say if we do the walkthrough the same day and then we found there's an issue, the heating is not working, right? Would there be an escrow that the buyer now can bring a contract in and see what the issue is? That's how it would work? Or?
Yes. If the purchaser during a visit to the property a day before the closing has found a condition which is inconsistent with the seller's promise, yes, you said that roof is leaking, for example. Take a picture of the roof. Ideally, if you can get an estimate from your roofer as to how much would the cost be for the repairs, you can actually go back to the seller at the time of the closing, provide evidence both in the photographic form and an estimate from a roofer. You can ask the seller to leave the same amount either in escrow with his attorney, or consider giving a credit to the purchaser, and the purchaser can do it himself after the closing. So these are the potential possibilities. Now, if you're not able to, which is very common, that you're not able to get an estimate from a contractor, then what do? Then you typically rely on your good judgment. You rely on sometimes attorney's judgment. Other people involved in the transaction can give you a reasonable amount, and then seller's attorney is going to hold some money in escrow, basically giving you a guarantee.
So you still close.
You write an agreement.
But the seller's attorney holds money for you to have enough time to and get an estimate, see how much it would cost.
Exactly.
And then whatever the cost is, the money will be released from the escrow, and then the balance will be returned to the seller.
Exactly. So you have you have a peace of mind, because adjourning the closing sometimes at that last minute is in no one's interest, unless something really major happens, which no one has any clue, which of course warrants that you do not take a risk, that you adjourn the closing, go back, consult with professionals, come back, confidently close. But if there are issues like the ones we talked about, the minor roof leak, or in one of the rooms the plumbing is not working or the heat is not working, you can work those things out with the sellers. But keep in mind, you should not make small issues as big issues, like creating a storm in a teacup. A lot of the time
sometimes it's difficult, the emotions running high, right?
Exactly. I see
the
people
sellers moving, buyers buying,
People sometimes start making a lot of hue and cry about scratches on the wall, scratches on the floor. Folks, you're not buying a new house. This is an old house. There is wear and tear. Small things are wear and tear. They're not damages to the property. So you got to make sense out of these things. You have to use your common sense and expect that there will be some problems. House will need constant maintenance in future. You have to be responsible. You have to be prepared for those kinds of contingencies. These are small things, not big things. So be mentally prepared. As long as those 4 things are okay, you should.
So those 4 things were roof, boiler, heating,
electrical, and the plumbing. Now, let me just tell you quickly, what is plumbing system? I mean, we're not plumbers, so what is plumbing? Well, make sure the water, wherever the water connection is available,
there's no leaks.
Make sure there are no major leakages. Minor faucet leaks happens all the time, but there should not be a leakage of a magnitude where it's creating a puddle in a house. Okay, so water is coming at a decent pace. Both the hot water and the cold waters are coming, and they're draining properly. This is your plumbing system.
Good water pressure.
Exactly. This is your plumbing system. So you don't need a plumber to find out if the plumbing system is working. Exactly. You're not going to go into the pipes, So you have to use your common sense. As long as these 4 things are okay, you should be fine. Don't read too much into small things that your inspector has raised in the inspection report, because that is his job. His job is not to scare you, but his job is to tell you all the problems in a house.
Correct. What I tell always to our buyers, the inspection is basically for you to budget for future what is you'll have to do.
Exactly.
Maybe the roof you got another 10 years, maybe the boiler you got another 5 years, hot water heater another 5 years, you might have to do a little fixing here and there, so it's for you to know exactly what the condition of the property is.
Exactly. One last thing I must touch. Sometimes, not all the times, I've been asked this question: what if the foundation of the house is weak and the house is about to sink? Folks, it's never going to happen, because the buildings department, once they issue a certificate of occupancy, they have made sure that the house does not sink. Okay, it does not happen. Frankly, I have not seen happening. Maybe once in a blue moon, there may be some settling in some portion of the house,
correct.
But it does not happen.
That the home was actually collapsed.
Exactly. Wherever there is a situation where a place which is called a dwelling place where people live has a problem of a nature where it can expose you to a potential risk to your life, then the buildings department with jurisdiction over that property is going to put a vacate order, which means this property cannot be used for living purposes. It's not safe. So if that is the situation, you will get a fair notice from the building department. If there is no such notice, do not worry about the foundation of the house.
Got it. Perfect. I think that pretty much covers the property conditions. Last thing, and it's always at the end of the transaction when we deal with the tenants issues and then possible post-closing possession.
Yes.
Can you elaborate on that?
Sure. So obviously when you are paying the balance of the price to the seller, you expect that you get the keys for the house on the day of the closing. 90% of the times, that is what happens. However, In certain small situations, which I would say 10% of the times, the seller is required sometimes 5 to 7 days to stay in the property.
They may be buying another home.
They're buying maybe buying another house,
Got it. So
but
they
look
have
at
to
it this way.
close, collect the money, and then move
Yes.
to another property.
Exactly. So you have to understand there are some practical risks for the sellers also. So you must appreciate and respect them. For example, what if you, at the time of the closing, do not show up for any medical emergency, or your bank fails to fund the loan? Something happened that prevented the closing to move forward. In that situation, if the seller has already moved out, he needs his money. He has probably stored his furniture somewhere, and he has his own closing going on. He has his own things going on that he has to go through.
Move all the tenants out.
Exactly. So
clean the home.
it's a huge risk for the seller that if the seller has already moved out and now suddenly he learns that the closing is not happening because of some unforeseen situation, in order to basically mitigate that kind of an extreme risk, the sellers request the buyers that the sellers be allowed to stay in the property for maybe about 5 days. So in those 5 days, the sellers are able to get their funds and smoothly transition out. The question for the buyers are, what if the the sellers are not going to give us the possession after those 5 days? In my experience, that has almost never happened. Why? Because we write up a post-possession agreement. Pursuant to that agreement, the seller is going to deposit a certain amount of money, which typically is about $3,500 to $5,000, depending on the size of the property. The seller is going to deposit those funds with his attorney, and he's going to promise that if he does not deliver you the keys after the 5th day or the 7th day, as the case may be, he's going to start paying a huge amount of penalty. Penalty could be anywhere between $250 to $350 per day.
Wow.
Well, that's the cost of basically a 5-star hotel. Why wouldn't they stay in a 5-star hotel as opposed to, staying in a property?
Staying in the house.
So almost never has it happened.
So those $350 to $500, that's the per diem a day, right? And that takes away from the escrow.
Yes. So I would say it's not a per diem, it's actually a per day penalty.
Per day penalty.
Per diems. So also the question is, those 5 days that the seller stays in the property, does he get a free ride? No, he does not. He pays for your mortgage interest, he pays for your property taxes, he maintains the property, he pays his insurance, and he pays his property taxes.
Understood.
So the purchaser does not have to pay for those 5 days, during which time he does not get to use the property.
Because the
Seller
purchaser
has
is
to
still
pay.
probably renting somewhere or staying
Exactly.
somewhere. So basically the seller will cover those 5 to 10
5
days.
exactly.
And that's the per diem that you guys break it down to exactly what the daily.
That is correct.
Understood.
The question becomes a little bit more complicated, however, if the property is occupied by tenants. Under the New York State law, now the tenants have acquired a lot more rights than they had before. So you have to be very careful these days if the seller is insisting that you accept the tenant, which was not part of the contract. If that is the case, then depending on that situation, you should actually protect yourself. I would highly encourage that for each tenant these days, you should consider anywhere between $10,000 to $15,000 of an escrow deposit that the seller must deposit with his attorney in order to guarantee that you get the possession within a reasonable amount of time.
Understood, because when you buy it with a tenant, the tenant doesn't want to move, the tenant doesn't want to pay.
Exactly.
You have to start the eviction proceedings.
Eviction
and you
proceedings.
have to still pay for your mortgage.
In New York
So you think
State,
for each tenant, $10,000 to $15,000.
minimum escrow should be
How long does it
considered.
take these days to evict a tenant? I mean, worst case scenario. Let's say we got a troublemaker who doesn't want to move.
It could take as late as a year.
Wow.
Yeah, that's a very long time, and in this time you're not using the property. You have to make sure you are making the
pay for
payments.
mortgage, yeah.
You have to pay your mortgages, and if you're renting the place somewhere, you have to pay your rents. So they could
Can be very
actually
costly.
very costly. So if you have a decent cushion in the form of an escrow deposit, that should be enough to compensate for your loss. So at least you're not paying out of your pocket. So
Now, does it give you a right to actually cancel the deal? If you, let's say, you said, no, I'm purchasing the property vacant, now at the time of the closing, the tenants are still there, does it give the buyer a right to actually cancel the deal?
it does not give the buyer an outright right to cancel the contract. However, the purchaser is not obligated to go forward with the transaction. He can adjourn the transaction he can insist the seller to remove the tenants, and until then, he doesn't have to close.
Or ask for the escrow.
Or in alternate, yes, if he's willing to accept the tenants,
And deal with-
but then
deal
he
with the-
must
deal with the
deal
headache.
with the headaches afterwards, because then you will have to hire an attorney because you're the
And it's
landlord.
time. So it's time and money.
Exactly. So these are the difficult decisions, which of course you should sit with your attorney, and hopefully if you have a real estate attorney, he should.
Only real estate attorney. We said no litigation, no criminal defense.
Yes, yes,
no
absolutely.
immigration.
It's extremely important that you retain an attorney who has experience in the real estate transactions. If you have another attorney who you love from your private transactions, but for a different kind of practice, for example, if you had a bodily injury issue, a family defense issue, like
It's
a
totally
divorce
different
situation, these are different transactions. They may not fully grasp and have understanding of the real estate transactions. That can actually expose you to a certain amount of risk. It's a rocket science. An attorney should be able to do some research. But for a small transaction, like a small one real estate transaction, if the attorney is not focusing heavily in real estate, it's possible that he may overlook one or two things.
Well,
and
put you on the back burner and you don't
Exactly.
really get the service you're looking for.
Exactly, and that can
Yeah,
be
I've seen it a lot.
potentially fatal to your transaction.
Especially
So
like with these union attorneys, they think they get a free attorney from the union,
Yeah.
and you can actually never reach the attorney.
and you get screwed.
It becomes very painful.
You get screwed then. So it's
Yeah.
highly important that you retain a real estate attorney who can give you the full and comprehensive representations during these difficult times.
I think that pretty much wraps it up. All the 7 points. I mean, we could go on and on and on and on.
Oh, absolutely.
Right? I mean, Shad, where people can reach you?
My office is in Forest Hills,
Yeah.
and that's where I have been for the past 12 years. I've been
Mhm.
practicing for almost 18 years now. As I said, I've closed over 10,000 transactions, residential, commercial, co-ops, condos throughout New York City and New York State. If guys, you have any questions, feel free to call my office, and I'll be very happy to give you free advice as and when needed.
Perfect. Thank you so much.
Thank you.
All right, guys, here you have it. 7 important points before you actually sign a contract or sell. We'll talk to you soon.